Welcome to the deep dive. You asked us to really get stuck into Hans Kelsen's legal theory, and well, that's exactly what we're planning for this session.
And this deep dive into Kelsen's legal theory is brought to you by Sinorbit Academy, Sri Lanka. Just a quick note. The information we'll be discussing today is based on materials made available to students by the University of London. It's intended purely for educational purposes. And good luck to all of you listening for your exams.
Absolutely. Good luck, everyone. Okay, Hans Kelsen. Right. Austrian lawyer, philosopher, 1881 to 1973. Now, interestingly, he wasn't from the Anglo-American tradition himself, but his ideas, particularly on the purity of law and legal validity, they've had a massive impact on it.
Oh, definitely. And he wasn't just, an academic theorist locked away somewhere. He was involved in practical things like drafting the Austrian Constitution back in 1921. He even wrote a guide to the UN Charter, so very much engaged with law in the real world.
That's a good point. So what was his main project then, this pure theory idea?
Exactly. At its heart, Kelsen wanted to develop a pure theory of law. And pure here means, well, free from specific political agendas or moral judgments. Think about those kinds of statements you sometimes hear, like Arthur Scargill saying Tory law is not law, or the Nazi regime dismissing Jewish liberal law. Kelsen would fundamentally disagree with that approach. For him, whether a law is legally valid shouldn't depend on whether you or I happen to agree with its content or its politics.
Right, so he's trying to understand law purely on its own terms, stripping away the ideology. So our mission today is to unpack Kelsen's core ideas, especially some of those bits that can seem a bit tricky, like the Grund norm. We want to give you a really solid framework for tackling this in your studies. Where should we start?
Let's begin with Kelsen's basic idea of what law actually is. He famously called it an order of human behavior. Sure, but maybe more importantly, a specific technique of social organization. And what's the key technique for Kelsen?
Coercion. Sanctions.
Precisely. Coercion. Through sanctions, crucially. Applied systematically by officials who are authorized by the legal order itself to do so.
Okay, sanctions applied by authorized officials. So for Kelsen, a legal norm isn't primarily, say, a command to us citizens like, don't steal. It's more like an instruction to an official.
That's the key insight, yes. A legal norm, in its primary form for Kelsen, is essentially a direction to an official telling them to apply a sanction under certain circumstances. It's like, if condition X happens, then official Y should apply sanction Z.
That feels a little counterintuitive, maybe. Because usually we think of law as telling us what to do or not do.
It does seem backwards at first glance, I agree. But Kelsen addresses this. He talks about the citizen's action that triggers the official's duty, like committing theft. He borrows the term delict for this. The delict is the condition under which the official is then directed by the primary norm to apply the sanction.
So the statement, one shall not steal, which seems aimed squarely at me, isn't what Kelsen would call a genuine legal norm in his main sense.
Not in its primary sense, no. He makes this distinction, which is really important to grasp. There are primary norms. Those are the ones directed at officials stipulating the sanction. And then there are secondary norms, like one shall not steal, which are directed at citizens. He admits these secondary norms are useful. They help us understand the law.
Okay.
But for Kelsen, the real legal norm, the fundamental one, the primary norm, is that instruction to the official about the sanction. It leads to that famous, slightly dense statement of his, law is the primary norm which stipulates the sanction.
Yes. And this norm is not contradicted by the delict of the subject, which, on the contrary, is the specific condition of the sanction.
Got it. That phrase really sums up his view on norms, doesn't it?
It absolutely does. It's a cornerstone of his theory. If you remember that, you got a key part of Kelsen.
Okay. Law is the primary norm which stipulates the sanction. Need to remember that. But hang on, didn't someone like H.L.A. Hart have issues with this very strong focus on sanctions? Yes, spot on. Hart raised a significant criticism. He famously pointed out that if you only look at the sanction element, it becomes difficult to properly distinguish between, say, a tax demand and a fine for a criminal offense.
How so?
Well, structurally, they might look similar in Kelsen's model. If X condition, income earned, speeding, then Y consequence, payment demanded. But Hart argued their underlying social function, their normative intention, is totally different. A fine aims to deter, to punish. A tax is primarily about raising revenue for the state. Hart felt Kelsen's sanction-centric view kind of missed this crucial difference in purpose.
That makes sense. It highlights the different reasons why we have those rules. Okay, so we have Kelsen's picture law as primary norms telling officials to apply sanctions if a delict occurs. But where does the authority, the validity of these norms actually come from? This must lead us to the Grundnorm, right?
Exactly, the Grundnorm. So think about it. Why is a particular bylaw valid? Well, maybe because it was made under powers granted by an act of parliament. Okay, fine. But then what makes the act of parliament itself valid?
Because Parliament passed it according to its own rules.
Right, but what makes those rules valid? You see, Kelsen argued that if you keep asking, why is this valid, you trace this chain of validity upwards. To avoid just going on forever in infinite regress, you have to eventually stop at some ultimate fundamental source of validity for the entire system.
And that ultimate source is the Grundnorm, the basic norm.
Precisely. It's the foundational assumption upon which the validity of all other norms in that legal system rests. So in your UK example, the bylaw is valid because of the Act. The Act is valid because it was enacted by the Crown and Parliament, and the validity of that process ultimately rests on the Grundnorm, which is something like the presupposition that whatever the Crown and Parliament enacts ought to be regarded as valid law.
Okay, so it's like the ultimate rule that says the rules made in this way count as law. It's the bedrock.
Exactly. Now, the term Grundnorm itself and how Kelsen sometimes described it can sound a bit, well, mysterious or abstract. He used words like transcendental, normative, epistemological. He explicitly said it wasn't an ethical political postulate, which is important.
Right, those terms can be intimidating. What did he really mean by them, like transcendental?
Okay, transcendental here basically means it's something outside the system of positive law itself. It's not another law passed by Parliament. It stands apart from and grounds the empirical legal norms. Normative just means it's about rules, about what ought to be, rather than just describing facts. Epistemological relates to how we know something.
Okay, so how does epistemology fit in?
Well, Kelsen saw the Grundnorm's function as primarily epistemological. It's the necessary intellectual presupposition or assumption we have to make in order to even recognize a system of commands or rules as a system of objectively valid law, rather than just, say, the demands of a gangster or a set of moral guidelines. It's the condition that makes legal knowledge possible.
Ah, I see. So it's not a moral judgment like this Constitution is good, but more like an assumed starting point that lets us say this Constitution is the source of valid law here. It's an assumption that lets us distinguish the tax inspector's demand from the bank robbers.
Exactly that distinction. When you're in a criminal law tutorial discussing, say, the Theft Act, 1968, you are implicitly presupposing its validity. That presupposition ultimately traces back to the Grundnorm of the UK legal system. Kelsen called it a transcendental logical condition. It's an assumption of validity.
That actually makes it much clearer, less mystical. It's an assumption we make to understand the legal order. So how does this foundational assumption compare to, say, Austin's idea of the sovereign or Hart's rule of recognition? That comparison seems important for studies.
Hugely important. It's a classic comparison question. Austin, remember, grounded legal validity in a social fact. The habit of obedience by the bulk of society to a sovereign who doesn't obey anyone else. It's about observable behavior.
Right, habitual obedience.
Hart similarly relies on social facts. His rule of recognition is the rule that legal officials actually accept and use in practice to identify valid laws. It's found in what judges, lawyers, legislators do.
Okay, so both Austin and Hart look to social reality in some way.
Correct. Kelsen, however, deliberately moves away from grounding ultimate validity in social facts. The Grundnorm isn't something you find by observing officials or citizens. It's a presupposition, an intellectual construct, a necessary assumption to make sense of the law's claim to validity. This is a fundamental difference.
So Kelsen is more philosophical about the logical requirements for understanding law's validity, whereas Hart and Austin are more sociological, looking at actual practices and habits.
That's a very good way to put it. Hart even criticized Kelsen on this, famously using the analogy of the standard meter bar in Paris. He said, saying the rule of recognition's validity is assumed but can't be demonstrated is like saying we assume the meter bar is 1 meter long. Its status comes from its acceptance and use as the standard, not from some further assumption about its validity. So, yes, Kelsen presupposition, Hart Austin, social fact. Definitely remember that distinction for exams.
Okay, Kelsen's Grundnorm as a presupposition, Hart's rule of recognition as a social practice. Got it. Now, what about when things go really wrong, like a revolution or a coup d'etat? How does Kelsen's theory, with its Grundnorm, handle such massive upheavals?
This is where Kelsen's theory becomes particularly relevant and, frankly, controversial. He defines a legal revolution as happening when the existing legal order is basically overthrown and replaced by a new one, but crucially in a way not authorized by the old order itself. Think a military coup, a successful rebellion establishing a new constitution without following the amendment procedures of the old one. It's an extra-constitutional event.
So a complete break from the previous legal framework. What does Kelsen say happens then to the validity of law?
He connects it directly to the idea of effectiveness. Kelsen argues that for any legal order, and therefore its Grundnorm, to be considered valid, the order must be, by and large, effective. People generally need to obey it. He calls this the principle of legitimacy. So if a revolution happens and the old regime completely loses control, it's no longer effective.
And if it's not effective?
Then, Kelsen argues, the old Grundnorm, the presupposition of the old order's validity, can no longer be reasonably presupposed. It loses its connection to reality, if you like.
Okay, so effectiveness is necessary for the Grundnorm to be presupposed. If the old system collapses, its Grundnorm goes with it. Does that mean the new system, if it is effective, automatically becomes legally valid, according to Kelsen?
Not quite automatically. This is a really critical point. Effectiveness, meaning the new regime has established factual control and people are generally obeying it, is a necessary condition for the possibility of recognizing a new Grundnorm. But effectiveness alone is not sufficient for legal validity.
Ah, okay. Necessary but not sufficient.
Exactly. For the new order to be considered legally valid, a new Grundnorm must be presupposed, even if it's done implicitly by judges, officials, or legal scholars interpreting the new reality. So you need both effectiveness and the presupposition of a new Grundnorm.
That's a subtle but crucial distinction. So even if a revolutionary government takes power and makes everyone follow its rules, those rules don't just become law because they're enforced. There needs to be this shift in the underlying legal assumption, the presupposition of a new Grundnorm.
Precisely. And Kelsen also explained what happens to the old laws that often continue under the new regime. He suggested that once a new Grundnorm is presupposed for the effective new order, it can tacitly validate the content of those old laws. But technically, they become new laws because their ultimate reason for validity, their grounding, has shifted to the new Grundnorm. It's not just the Constitution that changes, Kelsen argued. The entire legal order derives its validity anew.
This sounds like it would have major real-world implications, especially for judges trying to figure out what law applies after a coup. Were there any significant court cases where judges actually tried to use Kelsen's theory? This seems vital for exam prep.
Oh, absolutely. This is where things get really interesting and contentious. The most famous, or perhaps infamous, example is the Pakistani case, the State v. Dasso from 1958. After a presidential proclamation effectively nullified the existing constitution, Chief Justice Mohammed Munir explicitly referred to Kelsen's theory.
And what did he conclude?
Well, this is the crucial bit, especially for exams. Chief Justice Munir seemed to equate the sheer effectiveness of the new regime, its success, in taking control directly with its legal validity. He basically said the successful revolution itself was a law-creating fact. Now, this is widely seen as a misinterpretation, or at least a problematic simplification of Kelsen.
Right, because Kelsen said effectiveness is necessary, but you still need to presuppose the new Grundnorm for validity.
Yeah.
Munir sort of skipped that second step.
Exactly. He seemed to treat effectiveness as sufficient, which isn't quite the Kelsenian argument. This Dasso case is a key example of the difficulty courts had in applying the theory. You really need to know Dasso and this specific point about effectiveness versus validity.
Okay, the State v. Dasso, Pakistan, 1958, misapplied Kelsen by equating effectiveness with validity. Got it. Were there other similar cases?
Yes, there were others where courts grappled with similar situations, sometimes referencing Kelsen. For instance, Uganda v. the Commissioner of Prisons ex parte Matovu in 1966, and also the Rhodesian case, Madzimbamudo v. Lardner-Burke, also from around 1966, following Rhodesia's unilateral declaration of independence.
And did they handle Kelsen differently?
In Madzimbamudo, the judges initially were more cautious, distinguishing between the de facto effectiveness of the revolutionary government and its de jure legality. Although later, in a subsequent case, Arvi and Ndlovu, the Rhodesian courts did eventually accept the regime as legal based on its continuing effectiveness, moving closer perhaps to the Dasso outcome. It shows the real struggle judges faced.
It sounds incredibly complex for courts dealing with the immediate aftermath of such events. Did this use of Kelsen in courts continue, or was there pushback? Knowing the later development seems important, too.
There was definitely pushback, and this is also critical to know. Later cases, notably Jilani v. the government of Punjab back in Pakistan, and Lakanmi v. AG West in Nigeria, explicitly rejected the approach taken in Doso.
What was their reasoning?
These courts essentially said that Kelsen's theory, while interesting, is a jurist's proposition about law. It's a theory, an academic framework. It doesn't, in and of itself, grant legal authority to judges within their own legal system to simply declare a revolutionary regime valid just because it seems effective or fits Kelsen's model. They emphasize that judges derive their authority from the existing legal order, not from philosophical theories.
So a clear rejection of using Kelsen's theory as a direct source of law for validating revolutions.
Yeah.
That's a really important point. The courts in Jilani and Lakanmi basically said Kelsen is theory, not law.
Exactly. So you need to know Doso, Matovu, Madzimbamuto as examples where Kelsen was invoked, often problematically, and then Jilani and Lakanmi as key cases pushing back against that judicial application.
Right.
Remember those names: Doso, Matovu, Madzimbamuto, Jilani, Lakanmi.
Right. Got those case names down. Now, beyond the revolution context, Kelsen's theory itself has faced quite a bit of criticism, hasn't it? This is another area we need to cover for a well-rounded understanding for exams.
Absolutely. It's not a theory without its critics. One major line of attack focuses on this idea of the unity of his theory. By boiling everything down to sanctions directed at officials, Kelsen essentially lumps together criminal law and civil law. For him, ordering someone to pay damages in tort is fundamentally the same kind of legal technique as imposing a prison sentence for theft.
Just a different type of sanction applied by an official.
Pretty much. He acknowledged himself that achieving this kind of uniformity came at a high price. Critics argue that this reductionism obscures the very different functions, aims, and social meanings of, say, contract law versus criminal law. Does it really help our understanding to treat them as fundamentally the same?
Yeah, it does feel like something important might get lost in treating them identically. What else?
Well, related to that is the point we touched on earlier. Does law really seem primarily directed at officials in practice? Kelsen acknowledges his secondary norms for citizens, the one shall not steal type rules. He even says they greatly facilitate how we understand and represent the law.
So why aren't they the true law then?
Exactly. Critics ask, if these secondary norms are so important for guiding behavior and understanding the system, why relegate them to a derivative, not quite genuine status? It seems to create a gap between the theoretical model and how law actually functions and is experienced by most people.
That feels like a strong practical objection.
Yeah.
Were there also criticisms about his concept of a legal system being tied so tightly to one grund norm?
Yes, definitely. Critics question whether our understanding of a legal system really maps onto Kelsen's idea of just all the norms traceable back to one grund norm. For example, do we really think a completely new legal system springs into existence every time there's an unconstitutional change, however small?
Probably not.
Think about the Ghanaian case, Sala v. AG, which seemed to suggest legal continuity despite a regime change. And conversely, you could argue that maybe distinct legal systems, like, say, the UK and New Zealand historically, might share a common grund norm ancestry. Or within one territory, like Rhodesia after UDI, you might have changes happening that don't fit neatly into the idea of a total replacement derived from the original constitution.
So the idea of a legal system might involve more fuzzy things like history, culture, shared understandings, not just this neat pyramid structure based on one ultimate norm.
Precisely. Kelsen's model seems perhaps too rigid, too focused purely on the logic of validity, potentially missing the richer historical and sociological dimensions of what constitutes a legal system. And this leads to another major criticism. Is the grund norm itself actually redundant?
Redundant? How so?
Well, if the grund norm is just a very general presupposition like the Constitution ought to be obeyed, or coercive acts should be applied according to the historically first Constitution, does it actually do much work? Does it really help us identify which specific laws are valid within a system, or even clearly distinguish one legal system from another? Its content seems too abstract, too removed, to offer much practical guidance.
So it's central to his theory, but maybe doesn't add much practical analytical value.
That's the argument some critics make. Scholars like Joseph Raz, for instance, contrasted Kelsen's idea of justified normativity, where laws ultimately comes from the presupposed grund norm, with what Raz called social normativity, like Hart's theory.
And what's social normativity?
For Raz and Hart, laws are normative. They create obligations simply because they are identified as rules through accepted social practices mainly, what judges and officials recognize and apply as law. Hart's rule of recognition. They argue you don't need Kelsen's extra layer of a presupposed ultimate norm to explain law's normativity. Its authority comes from social acceptance and practice.
All right, back to the social facts versus presupposition distinction. Hart's meter bar analogy again.
Exactly. Hart saw the rule of recognition's authority deriving from its actual use and acceptance by officials, not from a prior assumption of its validity. There's also a more philosophical neo-Kantian reading of the Grundnorm as a sort of necessary mental category for us to even think about law as objectively binding.
Okay, that sounds quite deep.
It is, and it has its own set of philosophical debates around it. But the key takeaway from the criticisms is that Kelsen's focus on purity, sanctions, and the presupposed Grundnorm, while powerful, faces challenges regarding its descriptive accuracy, its explanatory power for certain legal phenomena, and the practical utility of the Grundnorm itself.
Okay, that's a lot to take in. Kelsen's theory is clearly intricate and has sparked huge debate. So let's pivot to really practical advice. For our listeners sitting down to study this, maybe revising for exams, what are the absolute must-knows? How should they focus their energy to really get Kelsen?
Right, this is crucial. First things first, vocabulary. You absolutely must have clear working definitions of the core terms. What is the Grundnorm? What's a norm? What's the difference between a primary norm and a secondary norm? What does Kelsen mean by delict? And those slightly tricky philosophical terms. Transcendental, epistemological, maybe ethical, political, postulate, and why the Grundnorm isn't one. Nail those definitions.
Master the key terms. Got it. Step 1, what's next?
Step 2, understand the two main pillars of the theory. First, Kelsen's view of law as that specific technique of social organization using coercion, focusing on sanctions directed at officials, primary norms. Second, his theory of the Grundnorm providing the ultimate validity for a hierarchical system of norms. See how these two big ideas fit together.
Okay, law as official directed sanctions and the Grundnorm as the validity foundation. Understand those two main parts and how they connect.
Third, and this is a classic exam area, be able to clearly compare and contrast Kelsen's Grundnorm with Hart's rule of recognition. Focus laser-like on that fundamental difference. Validity based on presupposition, Kelsen, versus validity based on social fact practice, Hart. Know the arguments for and against each.
Grundnorm versus rule of recognition, presupposition versus social fact. That's a key battleground.
Absolutely. Fourth, fully grasp Kelsen's ideas on validity and effectiveness. Remember that crucial relationship. Effectiveness is a necessary condition for validity. The system must generally work, but it's not sufficient on its own. You need to be able to explain that nuance clearly. Why does effectiveness matter, but why isn't it the whole story for Kelsen?
Okay, the necessary but not sufficient link between validity and effectiveness. Crucial nuance. And then the revolution theory in those cases.
Yes. Number 5. Get your head around Kelsen's theory of legal revolution. Understand how it connects validity and effectiveness when the system breaks down. And critically, be familiar with the key cases, the State v. Dasso and the misinterpretation point, Uganda v. Matovu, Madzimamuto v. Lardner-Burke. Know the basic facts and how the courts used or misused Kelsen. And crucially, remember the pushback in Jelani and Lakanmi. Knowing how the courts wrestled with Kelsen here is vital.
Theory of revolution, validity, effectiveness, connection, and the key cases. Dasso, Matovu, Madzimamuto, plus the later critique in Jelani and Lakanmi. That's a big chunk.
It is, but it's central. 6th, understand Kelsen's view on the unity of the legal system, lumping civil and criminal via sanctions, and be ready to discuss the main criticisms against it, loss of distinction, the focus on officials over citizens. Also, be aware of the criticisms about the practical usefulness and potential redundancy of the Grundnorm itself.
Right, the unity idea and its criticisms, plus the questions around the Grundnorm's real-world value.
And finally, try to form your own view. Having gone through all this, how useful do you find Kelsen's theory overall? Does it help explain things like why an administrative action might be ultra-vires, beyond powers? Considering the criticisms, where does its strength lie? Thinking critically like this is key for higher-level answers.
So definitions, the two main pillars, Grundnorm versus rule of recognition, validity, effectiveness, revolution theory and cases, unity criticisms, and then forming a critical overview. That sounds like a solid study plan.
I think if you cover those areas thoroughly, focusing on understanding the concepts and the key distinctions and cases, you'll be in a very strong position for any exam questions on Kelsen.
That's incredibly helpful. It really breaks down a complex topic. Kelsen's theory, despite the criticisms, certainly gives you a unique lens to view law and its foundations.
It absolutely does. It's challenging, yes, and it forces you to think hard about what we mean by law and validity. Engaging with it, even if you ultimately disagree with parts of it, really sharpens your understanding of legal philosophy.
So for everyone listening and studying Kelsen, we really hope this deep dive has helped clarify things. Do go back over these core concepts, the definitions, the cases. Think about those criticisms and where you stand. And maybe, as a final thought to mull over, considering all these debates, especially around the Grund norm, what do you think is ultimately the most convincing explanation for where law gets its authority, its validity in any given system? Something to ponder.
A great question to leave them with. We wish you all the very best of luck with your studies and, of course, with your upcoming exams.